Good afternoon, everyone, and welcome to the Assembly Committee on Commerce and Labor. Secretary, please take roll.
Assemblywoman Backus. Assemblyman Carter. Assemblywoman Duran. Here. Assemblywoman Hardy. Here. Assemblywoman Howdegi.
Here.
Assemblywoman Kasama.
Here.
Assemblywoman Monroe Moreno.
Here.
Assemblyman O'Neill. Assemblywoman Torres. Assemblyman Yeager.
Here.
Assemblyman Urick. Chair Marzola.
And I am here. Please mark members present as they arrive, and please mark Assemblyman Carter absent, excused. Today we will be hearing 4 Assembly bills: Assembly Bill 398, Assembly Bill 410, Assembly Bill 439, and Assembly Bill 441. Before we get started, I just have a few ground rules. Please turn off all your electronic devices. If you don't want to turn them off, please make sure they are on silent. If you wish to testify, please sign in at the table by the door. Leave your business card if you have one. If you have handouts for the committee, please provide 20 copies to the committee secretary prior to your testimony. For those testifying online, please be sure to mute your microphone when you're not speaking to minimize any background noise. When testifying, please turn on your microphone and clearly state and spell your name for the record. I expect courtesy and respect in all our interactions in this committee. And with that, I will now open the hearing on Assembly Bill 398, which makes various changes relating to insurance. Mr. Watkins, welcome back. Great to have you, and you may begin when you're ready.
Thank you, Chair. For the record, Justin Watkins, on behalf of Nevada Justice Association, that's JUSTIN, WATKINS, and I'm here to discuss with you Assembly Bill 398, and that's a bill that seeks to prohibit what are known as self-depleting insurance policies. I'd like to begin the presentation by providing a little background as to what self-depleting policies are, how they affect consumers, and then walk you through the very simple bill. A self-depleting insurance policy is a liability policy that reduces dollar for every dollar spent on attorney's fees, costs, or expenses. For example, if a business has a self-depleting, let's say $100,000 errors and omissions policy, say it's a law firm or a CPA firm, and makes an error that causes financial losses to a client, and the insurance company, in evaluating that claim, hires an attorney to assess the losses at an expense of, let's say, $20,000, then the only available insurance for the harmed party would be $80,000, that $100,000 minus the costs associated with the defense. If the $80,000 was insufficient to cover those losses and the injured party wanted to proceed towards litigation and have full access to a jury trial, it's very likely that at the end of that process there would be no insurance policy left, as a cost of trial is well in excess of 6 figures in almost any type of case in today's jurisprudence. These policies can actually be written to diminish not only within a single claim, but across multiple claims in multiple states. So in my practice, I've seen, say, policies of a small trucking company that are $10 million policies that are self-depleting across a 12-month time period, meaning that if my client was injured in the 11th or 12th month, there's very likely to be no coverage left, as other claimants throughout the country have depleted that entire policy. These policies are also problematic from an ethical standpoint of attorneys defending the insurance company or the business. The attorney who's in defense has the competing interests of ensuring that the company is rightfully represented, and at the same time that there is sufficient coverage to settle a rightful claim and protect that company from any personal liability above the insurance policies. And with that, I'd like to walk you through just briefly the 3 sections we have, or 3 subsections of Section 1 we have in this bill. As you'll see at the beginning, we're talking in Section 1 that without the limitations of any other insurance policy provision, that it will be prohibited in the state of Nevada to write an insurance policy that reduces, this is subsection 1, reduces the limit of liability stated in the policy for costs of defense, legal costs and fees and other expenses for those claims. I have heard from some interested parties and stakeholders that there is concern that this would include prejudgment interest, and I would just like to state for the record that that is not the intention of this section. The costs and expenses noted here would be as defined in NRS 18 and awardable by a court. That does not include pre-interest. The subsection 2 authorizes the cost of defense, legal costs and fees, and other expenses for claims to be applied towards the deductible. So similarly, the self-depleting policy cannot be applied towards the deductible that the company may pay before the policy comes into action. And then lastly, you'll see that there is somewhat of a catch-all here that in subsection 3, that there is no ability to limit the availability of coverage for the costs of defense, legal costs, and fees. So you can't find an end around towards this bill by saying, oh, we're going to write you an insurance policy but exclude legal costs and defense. The insurer still must provide for an attorney and pay for the legal costs and defense associated with it. And then I just would like to circle back and talk about the different types of insurance policies we're dealing with here. These are liability policies. So this would be auto policies, general liability policies, errors and omissions policies. Any policy that's in place to compensate a wrong that's been done, and that would limit civil remedies. And with that, I'll answer any questions.
Thank you, Mr. Watkins. We will start with Mr. Speaker.
Thank you, Madam Chair. Mr. Watkins, great to see you back in the building. Just had, I guess, a practical question. When a policy has a provision like this that takes into account cost of defense, legal costs, and fees, if and how are you able to advise your client as a plaintiff's attorney how much recovery might be available to them in the event that they actually win the case?
Justin Watkins, for the record, through you, Chair, to Speaker Yeager.
You can go direct.
Thank you. So, yeah, that can be the complicating factor associated with self-depleting policies on, I'll say, my side of the V. So when I have what I believe to be a legitimate claim against a carrier that has a self-depleting policy, when an offer is made that I think is below a fair offer, but I believe the cost of defense will take the policy below that fair offer, I have a difficult time picking out the moving target of how quickly the defense is going to spend their legal fees and at what point we have to, I'll say, cut our losses and accept the best that we can get of the insurance policy. On the other side of the V, having done the first 10 years of my career on insurance defense work, it is just as complicated to know how much you should be spending and investigating on behalf of the party. You don't represent the insurance company, you represent the party who's being sued, to know how much defense investigation I can do, how much money I can spend before I have put my client in the tough position where they are going to be personally liable for this loss because I've burned up too much of the insurance policy.
I have a follow-up, Madam Chair. Thank you for that, Mr. Watkins. And then I guess my follow-up to that, just in this conversation, it seems to me that certainly a plaintiff's attorney, but maybe a defense attorney, could put themselves in a pretty difficult ethical situation, but maybe one even touching on malpractice, right? If I'm advising a client that we should fight a case under the belief that there's $100,000 available, but in actuality it's like $20,000 available, that's a concern. But I just wondered, in your experience, do you know beforehand, like going into a litigation, that the policy has a provision like this? It would seem to me that you need to know that to be able to give good advice. So just wanted to ask, in your experience, is this something that the attorney and the claimant would learn about before making those sort of strategic decisions about how to proceed on a case?
Justin Watkins, for the record. Thank you for the question, Speaker Yeager. The answer is sometimes we know that it is a self-depleting policy before we file a lawsuit or move into litigation, but not always. And there is Other than auto policies, there is not a requirement in the state of Nevada that they must give me a copy of the policy, of the liability policy, before I file a lawsuit. Now, there is a requirement in the rules of civil procedure that they must disclose any policies of insurance in their initial disclosure, so somewhat early on in the process. And so if I didn't know before, once I filed the lawsuit, I do know now. But at that point, some of the money has already been depleted, no doubt.
Vice Chair Howdigi.
Thank you, Madam Chair. The Speaker actually asked my question, but I do have another one that I'll take the liberty to ask. So how many policies are there in Nevada that are these SDIP? Are they very popular? Do companies buy them because the annual premiums on them are less, I'm assuming?
Justin Watkins for the record. Thank you for the question, Assemblywoman. I can't give you a specific number, but I can say it's typically nationwide associated with types of practice. So errors and omissions policies that are on behalf of professional services, law firms, CPAs, doctors, any other professional services I can think of, often have an option of self-depleting policies because the deductible is much lower and the premium's much lower. So they're popular in that way. And then, like I said, in my practice, when you see these nationwide transportation companies, they often have these self-depleting policies. I'll give you one other practical example. I have a claimant against Sears, who has since gone bankrupt, and that claim has now been open over 6 years because of the bankruptcy. And in those policies with Sears and Kmart, they had a $5 million self-depleting deductible. And so we are stuck in those situations, even after bankruptcy, of there being virtually no coverage once the nationwide claimants are sort of sifted through.
Assemblywoman Backus.
Thank you so much. Welcome, former Assemblyman Watkins. And you started going down a path that I was almost thinking you weren't thinking it applied to, but now I take it that subsection 2 does apply to SIR policies. And with that, I know a lot of larger companies do utilize SIR policies because they can usually cover that first like $5 million, and that's a business decision that they're making. With that, and also the burning limits policies that are available for the E&O insurance, are you concerned that there may be a situation where professionals and larger corporations will make a decision not to carry insurance because of the higher cost and the premium that will naturally occur due to this restructuring of what is prohibited under Nevada law?
Justin Watkins for the record. Thank you for the question, Assemblywoman. Just for clarification, this does not outlaw or prohibit self-insured retention policies. You could still have a SIR policy. It's just that policy cannot be self-depleting. That is subsection 2 of the bill. And I think that this bill has as much for consumer protections for those businesses as it does for the claimant on the other side of the V. People are getting policies based on looking just at the premium, and in my experience, often don't know that their own policy is self-depleting and that they are going to be responsible for any amounts above the policy that is now virtually at the end worth zero. And so their personal assets, their business assets are on the line, and I think there's a consumer protection from that perspective. Obviously, I'm not a broker and I don't sell insurance policies, but I have not heard any objection from any stakeholders that say we don't think people can afford policies if this is in play.
And I appreciate that. And I also appreciate one thing, and I agree with you on those burning limits policies. I think as attorneys, there is that immediate duty. If you see that, you need to advise your client clearly when those burning limits are in play. And hopefully attorneys are taking that into consideration when they're looking at that. So thank you so much.
Committee members, any additional questions? Assemblyman Yurick.
Thank you, Chair, and thanks for the presentation. It's always good to see you, Mr. Watkins. Can you give us an idea how many other jurisdictions have enacted these sorts of prohibitions on these self-depleting policies? And can you tell us if there have ever been any unintended consequences or challenges to these laws?
Justin Watkins for the record. Excellent question, Assemblyman, and I don't have an answer to that. That's how I know it's excellent. I will look that up and get you an answer to that.
If you can get that answer to the entire committee, I appreciate it. Thank you. Committee members, any additional questions? I don't see any. We will go to testimony in support to Assembly Bill 398. Is there anyone here in Carson City wishing to testify in support to Assembly Bill 398? I don't see anyone. Is there anyone in Las Vegas wishing to testify in support to Assembly Bill 398? Broadcast, is there anyone on the line?
Thank you, Chair. If you'd like to testify in support of Assembly Bill 398, please press star 9 now to take your place in the queue. Chair, we have no callers wishing to testify in support at this time.
Thank you. We will move to testimony in opposition to Assembly Bill 398. Is there anyone here in Carson City wishing to testify in opposition? I don't see anyone. Is there anyone in Las Vegas wishing to testify in opposition to Assembly Bill 398? I don't see anyone coming to the table. Broadcast, is there anyone on the line?
If you'd like to testify in opposition to AB 398, please press star 9 now to take your place in the queue. Chair, we have no callers in opposition at this time.
Thank you. We will move to testimony in a neutral position. Is there anyone here in Carson City wishing to testify in neutral to Assembly Bill 398? I don't see anyone. Is there anyone in Las Vegas wishing to testify in neutral to Assembly Bill 398? I don't see anyone. Broadcast, is there anyone on the line wishing to testify in neutral?
If you'd like to testify in neutral for Assembly Bill 398, please press star 9 now to take your place in the queue. Chair, we have no callers in neutral at this time.
Thank you. We will now close the hearing on Assembly Bill 398. I will now open the hearing on Assembly Bill 410, which revises provisions relating to industrial insurance. Majority Leader, you may begin when you're ready.
Good afternoon, committee. I'm Assemblywoman Sandra Howdige, and I proudly represent Assembly District 41. I'm also the proud sister of Officer Adam J. Jackins, a 19-year law enforcement officer with the Reno Police Department. I'm here today with my co-presenters to present Assembly Bill 410, which revises provisions regarding the mental health injuries for our first responders. Most workers, including first responders, know they can file a workers' compensation claim if they get injured on the job. Still, many workers assume that their injuries or illness need to be physical in order to claim compensation. This may be because of how society has historically viewed mental illness, but that is changing. Post-traumatic stress disorder, aka PTSD, is a condition that is triggered by either experiencing or witnessing a terrifying event or a result of repeated exposure to trauma. No one knows exposure to trauma more than our first responders. First responders are often the first to arrive at the scene of an emergency or disaster. When people are running away, it is our first responders that are running into danger to save and protect our communities. The nature of work that our first responders engage in often involves traumatic situations, whether to themselves or the people around them that they are trying to protect or save. Dr. John Violanti, University of Buffalo, a retired NYPD officer, wrote in an article of the May 2018 Dispatch magazine of the U.S. Department of Justice, quote, Police officers are often exposed to traumatic events, such as seeing abused children or dead bodies, severe assaults, and involvement in shootings, and therefore are at risk for PTSD. Such exposure can impair the mental well-being of the officers and afflict their ability to perform duties to the public, end quote. NRS 616C.180 was enacted to cover PTSD for our first responders after 1 October. But as we learned once we pass laws and see its real-world effect, they sometimes have flaws. Right now, it only covers benefits for PTSD that are tied to one single event. For first responders who have developed PTSD after repeated exposure to some of the most horrific things imaginable, they are left without support and recourse. Committee, Assembly Bill 410 will help take care of those who take care of us during a time when they need help the most. Chair, with your permission, I would like to turn it over to my co-presenter, Officer Thomas Lopi with the Reno Police Protection Association.
You can begin when you're ready.
Good afternoon, committee. My name is Thomas Lopi with the Reno Police Protective Association. First name Thomas, Thomas, last name Lopi, Lopey. This law, or the changes to this law, would assist officers in seeking treatment and assistance for PTSD. Due to the unique nature of our job, we are constantly exposed to high levels of stress and trauma, which can take a significant toll on our mental health. I have a few statistics that I've pulled from various sources. EMS personnel, emergency medical services personnel found that 37% of individuals within that profession have symptoms of PTSD compared to 3.5% of the general population. That's over 10 times higher than the general population. Similarly, 14.8% of police officers reported symptoms consistent with PTSD compared to 3.5% of the general population. These also include anxiety disorders. Another study showed that out of 6,000 firefighters, 16.8% reported symptoms consistent with PTSD compared to 3.5% of the general population. Due to the unique nature of the job, we are expected to bring order to chaotic situations. We are expected to be the level head when we respond to chaotic incidents, chaotic scenes. When people are harmed, we are expected to remain calm and assist other people. We don't have the luxury to allow our emotions to take over when we're helping other individuals. And because of that, we're often left at home by ourselves with poor coping mechanisms, and we typically, and more often than not, we suffer from forms of complex PTSD or delayed onset PTSD. It's very difficult for us to tie our mental health or PTSD to a single defining event, because we do respond to so many chaotic events, and we do see just the most heinous crimes people can imagine. So the fact that we cannot, the current verbiage in 616C.180 does not allow us to file claims for a cumulative post-traumatic stress disorder. It's limiting our ability to seek assistance for our first responders. Our first responders need the ability to get assistance so that we can have longer careers. We're also seeing that individuals are retiring from law enforcement well before they max out their service. For currently, the law says for new hirees, it's 30 years at any age. We're seeing a lot of individuals in law enforcement and in first responder professions leaving after approximately 15 years. We're not getting to that end of our service. So with this bill, I'm hoping that we can provide the mental health assistance that we need for our first responders.
Thank you, Madam Chair. Assemblywoman Sandra Howdicke for the record. I did have a third co-presenter, Leslie Bell, Workers' comp representative with the Reno Police Protection Association. Unfortunately, she fell ill and was not able to be here, but if the chair would allow, I would like to send her written comments in, because she did have some statistics on how this could be a cost savings measure in the long run to share with the committee, since she was unable to be here. And before we go to questions, I also do have Dr. Steve Nicholas. He's a marriage and family therapist and nationally certified counselor, and Ryan Simpson, a marriage and family therapist and nationally certified counselor, here to help answer questions. Before we go to questions, I do want to walk the committee through the amendment, if that's okay.
Yes.
Committee members, you should have received an amendment that was just handed out. It was also already posted to NALIS. This amendment is a complete gut and replace of the bill that you read. So it would be this amendment taking full place. What my original intent was only to apply this to first responders, as I submitted it and tried to draft it myself. It applied to every state employee, and again, my intent was only to limit this to first responders. So the amendment that you have before you just makes some quick changes to 616C 180. First, it changes Section 1 sub 4. Section 1 sub 2 to say except as provided in subsection 4. And then in subsection 4, we removed the language that says shall not be deemed as a result of gradual mental stimulus. And we added in subsection B of subsection 4, or a series of events. So those three changes would be the entire bill. And again, that's to make sure that this only applies to first responders and that it's covering, again, a series of gradual events that they might have been exposed to that caused the PTSD. With that, we are now open for questions. Thank you.
Thank you, and thank you for your presentation. Committee members, are there any questions? Yeah. Mr. Speaker.
Thank you so much, Madam Chair, and thank you, Vice Chair, for presenting. I think you might have mentioned that this was in the written testimony, and if so, I'll look at that. But I just wondered, obviously we have this exclusion under the law now. Do we have any sense of how often these sort of claims are being made in the context of workers' compensation and being denied because the current law doesn't allow it? Or was that maybe in the written testimony of the presenter who wasn't here?
Thank you for the question, Mr. Speaker. Assemblywoman Sandra Howdy, for the record. Yes, that was actually part of Leslie Bell's presentation. I believe she has reached out to PERS to gather that information. That's information I can share with you and the committee once we get that over. Thank you.
Assemblywoman Monroe Moreno.
Thank you, Madam Chair. And I do not have a question. I just have a comment to thank you both for bringing this bill. I know firsthand how this will help so many of our law enforcement officers first responders in general, who run into danger. So just thank you.
Committee members, any additional questions? Assemblywoman Backus.
Thank you so much, and thank you for clarifying that, because I was starting to process how far this could go. But one thing I noticed is this provision, unlike some of the other provisions we were looking at, specifically defines who a first responder is under subsection 8, and it has in there sub B, sub 2, a police officer. And we've seen in other bills where this may get interpreted in different ways, where it's now just limited to police officers. And I was just curious if that was the intent, or who you guys imagined to be included in as a police officer.
Assemblywoman Sandra Howdy, for the record. Thank you for the question, Assemblywoman Backus. As defined in NR 617457, it actually lists out who is defined as first responders, and it includes police officers, firefighters, dispatchers. There's a full list of who would fall into that category under 617457.
Thank you so much, Majority Leader. I was just concerned because, like, in this section, it has specifically defines who a first responder is for this section. And unlike the other statutes we've looked at that have like a length, I was just concerned that this may just be limited to who the reviewers are looking at as who a police officer is. And that's under subsection 8 of the bill. And that's what I was just thinking of, like where we've seen situations where a marshal may not constitute a police officer.
Okay, so you want further definition for subsection 2, because in subsection 8, it's saying, as used in this section, a first responder means a salaried or volunteer firefighter, a police officer, an emergency dispatcher or call taker who is employed by a law enforcement or public safety agency in the state, or an emergency medical technician or paramedic who is employed by a public safety agency in the state. So your question is with police officer, like defining police officer further. I think my intent would be just to cover, because everyone else who's covered in this section is just those definitions of police officer who are defined under, those definitions of first responders who are defined under first responder in 8B. So just covering those people under 8B. I'm sorry, Assemblywoman, did that answer your question? Okay, perfect, thank you. Assemblywoman Sandra Howdiggy for the record.
Assemblywoman Duran.
For clarification, is that going to cover marshal, school police, tribal police net? That's what I think I need clarification on.
Thank you for the question, Assemblywoman. And Assemblywoman Sandra Howdiggy for the record. It's our intent to cover anyone defined as a peace officer.
And legal is going to clarify.
Thank you, Madam Chair. Sam Quas, Committee Counsel. The definition of police officer for the purposes of all of the industrial insurance chapters, so that's 6.1, is defined in 616A.283, and that ties into police officer, has the meaning ascribed to it in NRS 617.135, and 617.135 lists off specifically who is defined as a police officer, and so that's a sheriff, deputy sheriff, officer of Metropolitan Police Department, or city police officer, and then 16 others.
Does that answer your question? Any additional questions? I don't see any. We will move to testimony in support of Assembly Bill 410. Is there anyone here in Carson City wishing to testify in support of Assembly Bill 410? Please state and spell your name for the record. You have 2 minutes.
Thank you, Madam Chair. Jason Mills, JASONMILLS, on behalf of the Nevada Justice Association. We are in support of this particular bill because, as the sponsors and presenters pointed out, a major error that happens along these lines that Speaker Yeager brought up earlier is that, in fact, we do see claims regularly denied where we're seeing that they're being brought up as a gradual onset. So we get into these strange, weird fights over what was the specific incident, whether or not they had some more gradual onset stimulus, when in the reality, the police officer or firefighter is in fact clearly suffering from PTSD, and yet these claims are being denied. This would actually fix that particular issue, so we're in support of that. Also, with regard to the definition, absolutely, it would, as they pointed out from legal, that is our experience as well, that anything that is found in the NRS 616C.180 is referenced back to the 2 definitional aspects of police officer and clearly defined there in the Act. So we would like to thank the leader for bringing this bill and thank your committee for hearing it today and urge your support. Thank you very much.
Good afternoon, Madam Chair, committee members. My name is Jason, Jason Lesher, Lesher. I'm the president of the Washoe County Sheriff Deputies Association and also a representative of the Public Safety Alliance of Nevada. We wholeheartedly support AB 410 as a step in the right direction. This legislation seemingly works hand in hand with NRS 289510, which will require an annual behavioral wellness visit for peace officers. These visits will be designed to aid in preserving the emotional and mental health of our officers and will include an assessment of any conditions which may affect the performance of their duties to the public that they serve. At the federal level, our very own Senator Catherine Cortez Masto has championed legislation to address the chronic effects of PTSD on peace officers. Police suicide has been at an all-time high in recent years, and Senator Cortez Masto has been a leading advocate to pass legislation and reduce the instances of these tragic events. As it stands now, there is no recognition within the work comp system of the long-term effects of these mental health issues on our peace officers. AB 410 seeks to rectify this situation, and we stand in support and urge you all to do the same. Thank you.
Good afternoon, Chair, members of the committee. My name is Troyce, Troyce, Krumie, Krumme. I'm the current Vice Chairman of the Las Vegas Police Managers Association and a proud member of the Public Safety Alliance of Nevada. We stand in support of AB 410, specifically to bring on the gradual onset rather than a single set of circumstances. As an anecdotal that I will share, I spent 4 years on our child abuse and child death investigative team in Las Vegas, and while I will tell you, you might not be able to point to the first time you've seen something that the human eye is not supposed to see, you might not identify it the second time, but after about a 4-year period, when you separate and you take a moment back and you take a deep breath, you realize just how significant of an impact those series of events could be. So for that reason, I applaud the lawmaker that brought this forward and this committee and encourage them to support AB 410. Thank you.
Good afternoon, Madam Chair, members of the committee and staff. My name is Rick McCann, Nevada Association of Public Safety Officers and a member of the Nevada Law Enforcement Coalition. First of all, I want to thank Assemblywoman, Leader, whatever other title she's got this week, Howdigi, for sponsoring this bill. Simply put, as you've already heard, this bill creates an opportunity, just an opportunity, for stress-related claims by our first responders. Now, I know there will be opponents of the bill who will assert that it will open up chances for first responders to abuse the process. You know what, screw that. That's not what we're here to discuss, is opportunities to abuse the process. It allows claims for first responders who witness an event or a series of events proven by clear and convincing medical or psychiatric testimony. That's already in the law. They don't just get to hand it to them. They have a burden of proof. Make them prove it, but give them the chance to prove it. How many babies or children are these cops, firefighters, EMTs going to dig out of the bottom of a pool, try to resuscitate them, and fail in front of their parents? How many crashes are going to mangle bodies they have to pull out? How many suicides where brains are everywhere? How many burned bodies? I've represented these people for decades. I only do it for one reason, because they do things I can't well do. And neither can most of you, although there are some cops I'm looking at right now. You could. I can't. They deserve an opportunity for this claim. Give them this opportunity by supporting this bill, AB 410. Thank you.
Good afternoon, Chair, members of the committee. My name is John Abel. I'm the Government Affairs Director for the LVPPA, representing PSAN as well. I've been an officer for 17 years. I've been in 2 officer-involved shootings. I've seen numerous dead babies. I've helped pull babies out of a pool, and I was one of those officers 2011 and was watching my partner die. And in the year afterwards, I had a very difficult time mentally. Luckily, I had friends around me to help me, but the biggest thing for me was the stigma and helping officers realize that people support them and that they don't have to continue to do this job if they can't mentally handle it. So we advocate for this bill. Thank you so much. Bye.
Good afternoon, Madam Chair, members of the committee. Todd Inglesby, President, Professional Firefighters of Nevada. Sorry, got a little emotional hearing about Rick talk about that stuff, because I know for a fact this year alone that I buried 3 of our brothers and sisters within the last 6 months. One was a 22-year veteran who went through the process 6 years ago, got out of the process, but because of all the things that he responded to, he decided to take his own life. I had a 10-year person too within Las Vegas Fire and Rescue also do that. Again, I think Rick hit it on the head. This is just allowing us to file a claim, and I urgently ask for your support.
Thank you for your testimony. I know it's hard to share, but we do appreciate it.
Committee, my name is Christopher Waddle. I am the current president of the Reno Police Protective Association and a proud member of the Public Safety Alliance of Nevada also. I am currently a police officer with the Reno Police Department, and I have PTSD. Speaking back to the speaker's question, we had one officer last year that was denied based on this provision that I know of. So it is something that is very important. And as has been said, that it's not just to give me. It's not something that, we're just asking for everybody to get. It's something you still have to have you still have to qualify for. And I'm a very ardent supporter of this bill, obviously. And thank you very much for your time.
Good afternoon. My name is Dr. Steve Nicholas, Stevenicholas. I'm a mental health provider in our community here in Northern Nevada. I'm also a collaborative investigator for the DSM-5 TR, that's the Diagnostic and Statistical Manual of Mental Disorders, Text Revision 5th edition. And as a collaborative investigator reviewing the various diagnoses, PTSD, approximately 50% of the respondents, which were from the general population in those trials, demonstrated the likelihood that they were delayed onset of symptoms. And quite frankly, the DSM did not study specifically first response cultures. But as a clinician who specifically does work with first response cultures, there is no question in my mind and in my years of practice that delayed onset is the norm for first response cultures. Simply because these cultures are created, and quite frankly they should be to an extent, to train our valiant men and women to be prepared, be composed, and get it done. And you can feel later. But unfortunately, that culture, there's never a convenient time to feel, especially if you are understaffed and overworked. So our valiant men and women are in a culture that we're being assessed for acute stress disorder. And the likelihood of responding to acute single incidences is incredibly small. Because the truth is that there's maturational stress. These incidences, they mature, quite frankly, they mutate, they turn into the form of substance use disorders, massive divorce rates, suicide, death by suicide rates, among many other conditions. So the chronic nature of post-traumatic stress disorder is the norm for these populations. I overwhelmingly endorse the passage of this bill. Thank you.
Good afternoon, committee members. My name is Brandon Casanelli, for the record, Brandon, last name Cassinelli. I'm a 15-year veteran of the Reno Police Department, and I am also a licensed marriage and family therapist intern for the state of Nevada. For the preceding 4 years, I've held a very special role within the Reno Police Department. The title is Embedded Resource Officer, and this position was created specifically to address some of the ongoing concerns you've heard already from testimony regarding mental health stigma and the engagement with the same. I'd like to provide a little bit of insight into what this is costing us practically and pragmatically. I'm glad that Assemblywoman Howdeggy mentioned John Violante. He's a prolific researcher in this field. He cites in a 2016 study that the three major stressors that anyone experiences with regard to their job, but especially first responders, are organizational, personal, and operational, with organizational being ranked at the top. And whether we like it or not, we are all part of the same governmental organization in one form or another. And I can testify to the statement that for the last 4 years, in one instance, to regard to your question, Mr. Speaker, that presently we're faced with two options. Either we cite a single event or people are retiring early. And according to a 2021 study from Caliber Press and Police One, voluntary early retirements, qualification for full benefits, are up 196% in the last 10 years, and that's in police fire. People are either leaving the job or they're taking their own lives. This provides them a third option and allows them an ability to sense and feel that they are loved, respected, cared for, and actually a part of the communities they serve. I fully endorse this bill as well. Thank you very much.
Paul Klein, Paulklein, on behalf of the Nevada Police Union, your Nevada State Police. We concur
with all the sentiments, very moving testimony that you've heard before you, and we support this bill.
Thank you. Is there anyone else here in Carson City wishing to give testimony in support of Assembly Bill 410? I don't see anyone. Is there anyone in Las Vegas wishing to provide testimony in support of Assembly Bill 410? Broadcast, is there anyone on the line wishing to testify in support?
If you'd like to testify in support of Assembly Bill 410, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 167, you are unmuted and may begin. Caller with the last 3 digits, 167, is your phone muted?
Hello, my name is Sean Tebow, SHAWN-GHIBEAULT. I am the president of the Henderson Police Officers Association in Henderson, Nevada. I'm also a 16-year veteran of the Henderson Police Department, and in total a 30-year veteran of law enforcement. We, the Henderson Police Officers Association, concur with all of the testimony he has given here today, and would hope that you would give back to the people that give so much. This is going to mean a lot to a lot of people. We support this bill. Thank you.
Thank you for your testimony. Broadcast, is there anyone else on the line?
Hi, this is Katrina Ivanov, aka Mrs. Sixes, Assembly District 42. This is the most common sense bill I have heard this whole session. Please support this bill. I will always support first responders and veterans. Those are the people that give the most from their personal life. They do the most sacrifices. And one of the people mentioned that some people would take advantage of it. In every single profession, in every single group, in every single country, there are bad apples and good apples. Only because they're going to be a couple of bad apples, we should not deny the people that are helping us the help when they need it. Because when you go into that kind of profession, firefighter, policeman, first responder, you go in there because you have a calling most of the time, 99% of the time. You don't go there in that profession because you want to take advantage of something. Let's face it, they don't get that paid that well. And I cannot believe that they're going through all these troubles because of some kind of loophole in the law. We have to rein something on those insurances. This is a common sense bill. Please support this bill. Thank you. Have a lovely day.
Thank you, ma'am, for your testimony. Broadcast, is there anyone else on the line?
If you've recently joined and would like to testify in support of Assembly Bill 410, please press star 9 now to take your place in the queue. Chair, there are no more callers in support at this time.
Thank you. We will now hear testimony in opposition to Assembly Bill 410. Is there anyone here in Carson City wishing to testify in opposition?
Good afternoon, Chair Marzola and members of the committee. Lindsay Knox with McDonald Carano, here representing the Nevada Self-Insurers Association and the Las Vegas Chamber. We are here in very, very soft opposition, as we believe that we can work with the majority leader on a fix to this to make sure that our first responders get the proper care. Thank you.
Good afternoon, Chair Marzola, members of the committee. My name is Beth Schmidt, SCHMIDT. I represent the Las Vegas Metropolitan Police Department. Per the rules of the committee, we are also in opposition to AB 410 as written. We appreciate Assemblywoman Hardigay's willingness to gather stakeholders to discuss this very important issue, and we look forward to continuing to work with her on this bill. The LVMPD is concerned that AB 410 as written will not accomplish what we all want, which is timely, available mental health care for our first responders. One of our concerns is that mental health care under workers' comp is limited. Employees under workers' comp are restricted to seeing doctors on the DIR list and even more limited to seeing doctors that will accept workers' comp payment because these visits have to be billed under the Nevada fee schedule. To the best of our knowledge right now, there is one psychologist in the Las Vegas Valley that is available to treat our employees under workers' comp. To be clear, LVMPD is committed to prioritizing our employees' mental health specifically and their wellness more broadly. To that end, LVMPD first responders have free, unlimited mental health coverage under our health plan. Having this in place allows our employees to seek care from any mental health provider that accepts health insurance. We would encourage all agencies with first responders in the state to provide similar services under their health plan. We look forward to continuing to work with Assemblywoman Hardigay on AB 410.
Hello, committee. My name is Ashley Garza Kennedy, representing Clark County, and I will just ditto the comments that have been said before. In Clark County, we support our employees who do this really difficult work, as you heard in our testimony today, and that's not lost on us. We do have similar tools, and we want to ensure that our employees continue to have those tools so they can continue to do the job that they that we ask them to do. We have some technical concerns about the bill as written and as amended that we will continue to work with the sponsor through, and appreciate your time. Thank you.
Thank you, Madam Chair. Members of the committee, Nicole Rourke, representing the City of Henderson, also would like to echo the comments of the Nevada Self-Insured Association and just add that the city recognizes that first responders' jobs are very stressful just by nature. We've recently dedicated time to expand mental health benefits through our self-insured policy, as well as through a wellness initiative. We're actually getting ready to open a wellness center for our first responders to make their access easier actually in this area. So by providing resources for our first responders in this manner, we are not overburdening our workers' compensation program and are not creating delays that may be associated with those investigations. So with that, we really look forward to working with Assemblywoman Hardigay on how to find the exact right approach to provide mental health support for our first responders. Thank you.
Good afternoon, Chair. Vincent Guthreau, spelled Guthreau. First name is Vincent, Vinson. I'm the Executive Director of the Nevada Association of Counties. I'll just simply say I echo the comments of the folks that went before me. We look forward to continuing some stakeholder conversations to get some of the technical things ironed out and get this to a workable place. Thank you very much.
Is there anyone else here in Carson City wishing to testify in opposition to Assembly Bill 410? I don't see anyone. Is there anyone in Las Vegas wishing to testify in opposition to Assembly Bill 410? I don't see anyone. Broadcast, is there anyone on the line wishing to testify in opposition?
If you'd like to testify in opposition to Assembly Bill 410, please press star 9 now to take your place in the queue. Chair, we have no callers in opposition at this time.
Thank you. Is there anyone here in Carson City wishing to testify in neutral to Assembly Bill 410? I don't see anyone. Is there anyone in Las Vegas wishing to testify in neutral to Assembly Bill 410? Broadcast, is there anyone on the line wishing to testify in neutral?
If you'd like to testify in neutral to Assembly Bill 410, please press star 9 now to take your place in the queue. Chair, we have no callers in neutral at this time.
Thank you. Majority Leader, you may begin when you're ready.
Thank you so much, Chair. I'm going to keep my closing remarks brief because I can't say it any better than those who were here in support of Assembly Bill 410. So I just want to thank the committee for hearing it and urge your support. Thank you.
Thank you, and thank you again for bringing this very, very important bill. I will now close the hearing on Assembly Bill 410. I will now open the hearing on Assembly Bill 439, which revises provisions governing contracts of insurance. Welcome, Mr. Sharp, and you may begin when you're ready.
Morning or good afternoon, Assemblywoman Marzola, members of the committee. I'm here on AB 439, and it basically deals with a simple subject matter of forced arbitrations in health insurance contracts. Fortunately, the bill as written was a little overbroad. Unfortunately, those communication things happened, so we presented an amendment that I hope all of you have received. Basically, what the amendment does is it includes a provision that essentially is the same as what already exists under Nevada law in the context of uninsured and underinsured motorist coverage. Essentially, the same language we have in the amendment is already existing law as it relates to uninsured and underinsured motorist coverage. The reason why I point to that is the provision under existing law that's been existing since 1979 in the context of uninsured motorists just simply says an insurance company can have an arbitration provision in an insurance policy, but it's not binding on the insured. So what that basically means is if the insured wants to assert their Seventh Amendment right to trial by jury, they can do that. If they want to submit to arbitration, they can do that. So basically what this bill does for health insurance is says when we're dealing with issues as fundamental as our own health, that you should have the right to a trial by jury when that right is available. And that's really all this bill does. It doesn't cast doubt upon arbitrations when they're mutually agreed to. It simply says if you're going to have a provision, it should only be binding upon the insurance company. So the insured continues to have the right to have a trial by jury. And the rationale behind that is the insurance companies write the contracts. You as a consumer have little to no say over those contracts. You should be able to maintain your constitutional right. And with that, I mean, I can deal with the more specific provisions. There is approximately 4 provisions to existing law that would be repealed under our amendment. And those repeals deal with arcane arbitration provisions that frankly don't have a lot of current aptitude in our current makeup as to how we litigate cases. But again, it comes back to the same point that an insured state of Nevada dealing with matters as important as your health care should have a right to trial by jury. With that, if there are any questions, Madam Chair, I'd be happy to answer them.
Thank you, Mr. Sharp, and thank you for your presentation. Our first question is from Mr. Speaker.
Thank you so much, Madam Chair. Good to see you, Mr. Sharp. I just want to make sure I understand. I'm looking at the amendment and just want to make sure I understand what it is doing in context with the bill itself. So it looks to me that you're wanting to limit this to just the sort of healthcare related contracts of insurance. And I note in the bill, it looks like it's deleting, the amendment deletes sections. Actually, let's see, it deletes sections 1 through 3. So we wouldn't be talking about life insurance. We wouldn't be talking about credit insurance, I guess all those sections that are being deleted. So it's just the healthcare piece is saying what it's limited to, right?
Yes, Assemblyman Yeager, that is correct.
Can you state your name for the
I'm
record,
sorry.
please?
Matthew Sharp from the Nevada Justice Association. And Assemblyman Yeager, you are correct, and the rationale behind that is all of the different types of policies that you're generally referring to do not have those provisions. It's only in this unique area of health insurance that we are dealing with this problem.
Any additional questions, committee members? I don't see any. I just have a quick question. Are you able to give us an example of how this comes up?
Yeah, so how this would come up in the real world, again, Matthew Sharp, Nevada Justice Association, Assemblywoman Marzola. A real world, I don't know how, I don't want to get too much into the details and the weeds, but generally speaking, in group health insurance, that's your employer-employee-based insurance. So there are, almost everyone is governed by a federal law called the Employment Retirement Income Securities Act. There are very small portions of people who are not. And so what the insurance industry has done is they've said, for those people who are not subject to ERISA, we want to force you into forced arbitration. Now, the irony is that all of you have these policies that say you are to be forced into arbitration. They're never asserted in the context of ERISA, and we can deal without getting into the minutia. The reason being is because the remedies are already limited. Under ERISA, you don't get a trial by jury. So what we're saying is in this small group of people that have state rights, they should have the state right that our founders said we have, which is a right to trial by jury, which is guaranteed by both the U.S. Constitution and the Nevada Constitution.
Thank you, Mr. Sharp. Any additional questions? I don't see any, so we will move to testimony in support of Assembly Bill 439. Is there anyone here in Carson City wishing to testify in support? I don't see anyone. Is there anyone in Las Vegas wishing to testify in support to Assembly Bill 439? I don't see anyone. Broadcast, is there anyone on the line wishing to testify in support?
Callers, if you'd like to testify in support of Assembly Bill 439, please press star 9 now to take your place in the queue. Chair, we have no callers in support at this time.
Thank you. We will move to testimony in opposition to Assembly Bill 439. Is there anyone here in Carson City wishing to testify in opposition? I don't see anyone. Is there anyone in Las Vegas wishing to testify in opposition to Assembly Bill 439? I don't see anyone. Broadcast, is there anyone on the line wishing to testify in opposition?
If you'd like to testify in opposition to Assembly Bill 439, please press star 9 now to take your place in the queue. Chair, we have no callers in opposition at this time.
Thank you. Is there anyone wishing to testify in the neutral position to Assembly Bill 439 here in Carson City? I don't see anyone. Is there anyone in Las Vegas wishing to testify in the neutral position? I don't see anyone. Broadcast, is there anyone on the line wishing to testify in neutral to Assembly Bill 439?
If you'd like to testify in neutral for Assembly Bill 439, please press star 9 now to take your place in the queue. Chair, we have no callers in neutral at this time.
Thank you. Mr. Sharp, would you like to give closing remarks? I will now close the hearing on Assembly Bill 439. I will now open the hearing on Assembly Bill 441, which revises provisions relating to industrial insurance. Mr. Mills, Mrs. Grimmer, you may begin when you're ready. And Mr. Hooks.
Madam Chair, Jason Mills, JASONMILLS, on behalf of the Nevada Justice Association. I would like to, on behalf of our organization, I'd like to thank you personally for bringing this bill on behalf of your entire committee, and it is much needed. I can report to you that we have spent several months with the major stakeholders in negotiating the terms that are in the amendment that should be before you today, specifically the Nevada Resort Association, the Nevada Self-Insured Association, and Employers Insurance Company of Nevada as major stakeholders, as well as the NJA, don't rarely come to the table in full support of bills, but when they do, we try our hardest to get a good bunch of policy in front of you all. What I'm working from today is the AB 441 proposed amendment that says that it's proposed by the Nevada Justice Association that you should all have access to. I believe it consists of 32 pages. I will briefly go through each section. I know we're moving along quite well today, and I want to keep it in those regards for you. With regard to Section 1 of this bill, what this essentially allows us to do is to have available for inspection electronically of the files for workers' compensation files. Currently, that is it's all physical inspection rules. Section 2 also indicates that rather than having access to just the complete file, a reproduction of that complete file as well as will be sufficient for the ability to review them. With regard to subsection 3, what this provision does is it requires the Division of Industrial Relations to begin to publish the information on a quarterly basis for when the assignment of permanent partial disability physicians. These are typically at the end of the claim. We'd like the division to actually publish whom these assignments are going to. I can report to you that for more than a decade, my organization and others have tried to parse out from the Division of Industrial Relations precisely how these random rotation assignments occur and who's getting these particular assignments. I can report to you for a long, long period of time, we have never really got any answers out of them. So we think that this publicly publishing this information will be useful for all stakeholders involved. With regard to Section 4, this is an amendment to existing law that would allow right now, the insurers are required to use a master list that the Division of Industrial Relations has to compile their treating physicians in the workers' compensation space. A problem arose over the last few years. This was an amendment from 2017. It was a fantastic bill brought by Senator Cannizzaro. But what's happened is for several years is that doctors have signed up to be treaters in particular subspecialties that they actually don't treat. So imagine for insurers and employers and claimants when we want to utilize Dr. X, and because he or she has listed his or her name as that type of subspecialty treater, and they don't actually do the treatment. So all this does is say that if you're going to name yourself as a treating physician in a particular subspecialty, you should be required to treat and accept those particular claims. With regard to subsection 5, which I believe, I'm sorry, I point that out also in later on in subsection 4, that they must also accept and treat employees under the Workers' Compensation Act, or else they'll be removed from these panel lists. So just adding yourself on a panel list and then not actually accepting and not actually treating is useless to the insurers, employers, and the claimants. So we just want to make sure that the doctors are actually going to do that when they're on these lists. If not, they would be removed. Lastly, there's also been confusion for the insurers, the employers, the division, and claimants that these lists that the insurers file are in various different formats and often aren't in searchable database form, where this would require the division to produce a format or style, and various different searchable formats could be used, whether it's an index database, a PDF file, a CSV file, et cetera, that are actually searchable and usable for everyone in the community to actually see, rather than just, oftentimes they're just random order pixelated images rather than searchable files. Section 5 of the bill does several things. It addresses what should happen if a physician or chiropractor doesn't treat a particular specialty, and that is that it is hard for the division to know whether or not doctors are or aren't doing this stuff, but the insurers, the employers, and the claimants are people that are regularly interacting with these doctors and do know when the doctors are or aren't doing this. So we're inserting a provision that says, hey, essentially we can notify on a form that is prescribed by the administrator that says, we think maybe that a physician isn't actually treating, and any person can submit this to the division, and then the division has essentially 90 days to go figure out if the doctors are in fact treating or not and accepting these type of claims. And if they're not, they would effectively be removed from that sub-panel list. A good example is, for example, if a doctor lists he or she does spine surgery, shoulder surgery, knee surgery, elbow surgery, hand surgery, ankle surgery, hip surgery. I don't know of any doctor that actually does that in the 21st century, right? But the problem is maybe that doctor's staff or himself or herself accidentally filled the form out that way. So if we said, hey, by the way, Dr. X is actually only doing knees, can you check him for the spine, the shoulders, and everything else, and the division ascertains he or she isn't actually doing that, they would only be removed from those subspecialties that they're not treating and accepting, right? Which makes sense. And of course, if a doctor or physician changes their role or their practice in the future, say they are a shoulder doctor and now they also want to do knees, because that's very common, shoulder and knee doctors will do those both body parts, but say they wanted to expand into that at a future date, they can always reapply to that other subspecialty and then be easily added. Section 6 has to do with clarification on the use of the independent medical examination. That is a right that this body granted about in 2017, and it's frequently used for an initial or even a second permanent partial disability examination. There has been some concerns over the last few years in litigation whether or not it conflicts with an existing law that's on statute. So what we've done is clarify that we can use this independent medical examination right for an initial permanent partial disability examination or a second or subsequent permanent partial disability determination. And if the claimant does utilize this particular right for a second examination, if he or she ends up getting not a greater amount than what the insurers had actually offered, then the insurers would be allowed essentially an offset of the cost of those exams, which are usually around $1,000, but only against their recovery of their permanent partial disability award. There wouldn't be an out-of-pocket charge or against their medical rights or anything like that. So if they're entitled to an award and they wanted to fight for a higher award utilizing this particular bill or provision, and then it doesn't come out higher, the insurers effectively have quote-unquote wasted $1,000, and the provision would, I'm using 1,000 as an example because that's roughly usually what PPD exams are, they'd be able to recapture that, right? And we also clarified that permanent partial disability exams under the IME statute fall under a particular cost provision rule, and the IMEs of the rest, an IME independent medical exam, under the rest of the statute falls under the independent medical examination charging fees. That has been a point of consternation or confusion for insurers and physicians over the last few years, and this seeks to clarify that. Section 7 of the bill changes the way the rotating physicians and chiropractors are selected. Again, we've been trying for over a decade to figure out how the assignments actually take place. We mostly get Wizard of Oz behind the cape kind of stuff, and we never can ever figure it out. So one of the things that we're trying to do is just insert essentially randomness into the process because randomness can't have thumbs on the scale, right? So that's what we're attempting to insert in there. We're also removing the requirement for quote unquote specialization on permanent partial disability examinations. We think that's an anachronistic problem that for years the AMA guides, that's the American Medical Association guidebook for impairment that we're required to use in PPD examinations. These physicians go out and are trained on that guidebook. So often chiropractors, for example, will rate fusion procedures or surgery shoulder provisions, yet they don't actually do those in their day-to-day life, but they're very capable of understanding how that guidebook works. So the fact of the matter is, as long as you're able to use this guidebook, your area of specialization isn't that important. We actually run into problems on these particular issues, and I can give you an example. For example, there are 2 physicians that I know of in the South that are currently able to rate the eyes, but the guidebook says what and how you rate eyes. Now, we're in a situation where the rules say that you can only have one treating, or the treating doctor can't also rate the person. So when the treating doctor treated for the eyes, now that leaves only one person for the rating. What happens if Mr. Hooks' client or Ms. Grimmer's clients or my client wants to challenge that first rating? There's no one else to pick. When in fact the point is that specialization requirement, if lifted, as long as the physician has passed the guides testing requirements, which they do in order to get their licenses here in Nevada, then that specialization rule should be lifted and not exist because, again, more than 70% of the rating physicians are chiropractors, and none of them do fusions or shoulder surgeries, and they're already rating those body parts to begin with. So this particular provision doesn't make much sense to us. And we also add a provision in there that a doctor can always say that, hey, I got an assignment that I'm not comfortable with. Perhaps a neurologist doesn't want to rate a heart exam because they're just not comfortable doing it. Then they have the right to say, hey, Division of Industrial Relations, I don't want to accept that. Just like, for example, a lawyer might not be is legally allowed to defend a federal death penalty case, but I can assert to you that I have no business defending a federal death penalty case, and I would tell someone if they tried to make me go do that. We think the same thing or rule should apply to the physicians if they get an assignment that they don't think is correct for them, that they just raise their hand and say, no thanks. And then the division assigns the next person randomly from the list. Carrying on, at the end of that section is the division will be, again, required to report annually which doctors are getting these assignments and what are they turning away so that we can then verify down the road, is this a problem or not? Section 8 deals with a particular problem on lump sum awards. There was some confusion on whether or not when a claimant would sign his or her election for a lump sum on their award, they're allowed to do that under the law, what actuarial table should be used. What we're basically saying is whatever actuarial table is in effect on the date when they make their election, that will be the one that will be used. Seems to make sense to us, whatever, because the table changes every year based upon what's happening in mortality rates and 30-year treasury bills for the United States. So every year the table adjusts for an entire 12-month period. And when the claimant makes his or her election, the date upon which they make their election, whatever table is in effect on that date should be the table that is utilized, not the prior table, not the future table, the one that's in effect on the date they make the election. Section 9 has to do with a strange thing in the existing rules, and that is if we file what's called a complaint against an insurer or an employer about something that they're doing in their claims management, we do not have bad faith in the state of Nevada for workers' compensation handling, so it's all done through a chapter called 616D, particularly subsection 120. So when we file complaints on those things, the Division of Industrial Relations often will do an investigation. But existing law says that they have 90 days to do that investigation, but we only have up to 100 days to appeal if the division doesn't do anything. So what that means is there's only a 10-day window to appeal if the division does nothing. We're expanding that out to say out to 120 days so that there's a true 30-day window to appeal, not a 10-day window. Another problem that exists is that under current law, after the division does nothing for 90 days, Current law says that it's deemed denied. So if the division does nothing on my request for a complaint, the law already says it's denied. Yet we're running into a strange situation when we appeal those and we go to the appeals officer. Weeks, months, sometimes even years later, the division will jump in and say, hey, we went ahead and finished that investigation on it, and here's our findings. But the law already deemed it a denial. Why are we doing that, and why are we doing it later? So what we're doing in this particular provision is, look, after the division hasn't acted in that 90 days, we have that additional 30 days to appeal. They do as well, both parties, all parties. If they don't like the outcome of that, they can appeal it. And the jurisdiction over whether or not a benefit penalty should exist or not now will just rest with the appeals officer, essentially the court, the one that's deciding these things, rather than the division running back in 3 weeks, 3 months, 3 years later, and causing confusion into the process. That has to do with the sections that I'm covering. I believe the remaining sections I will turn over to Misty Grimmer with the NRA and Dalton Hooks with the NSIA. Thank you, Madam Chair.
– Thank you, Chair Marzola and committee members. Misty Grimmer with the Ferraro Group, actually most importantly representing Employers Insurance Company today on this bill. We always wear the Resort Association hat too on all the employer issues though as well. So, but for the most part today it's for Employers Insurance Company. As Mr. Mills has already noted, this is sort of the usual NJA, Employers Insurers, TPA show with respect to workers' compensation. Like most legislative interims, back in the summer, we began chatting with each other about some changes that would improve the workers' comp system for all parties. We all come to the table with a list of asks. Some of them we can agree on and some we don't. Those conversations continued once we got up here, and AB 441 is the result of those conversations. Mr. Mills has walked you through most of the sections of the bill and the reasons for those changes. I will focus on just 2 sections that are particularly important to Employers Insurance Company. Section 10 references the physical location of insurance adjusters who adjust workers' compensation claims. Work comp, I believe, is the last type of insurance that still requires adjusters to live in the state of Nevada. Most insurance adjusting is done virtually these days, and the same could happen for workers' comp except for the current statutory requirement. What we are proposing is that the adjusters who are employed by insurance companies be allowed to be located outside of the state of Nevada. They would still be required to have whatever training and licensure is required by the Division of Insurance, but would not have to physically be here. They would, however, have to be available for Nevada working hours. The TPAs have requested that for their adjusters, they do still have the residency requirement, so the flexibility requested in the law in this bill is just intended for insurance company adjusters. The Department of Insurance has suggested the addition of some language to this section to make it clear that all adjusters, whether with an insurer or a TPA, are still required to be certified as TPAs by the Division of Insurance, as adjusters by the Division of Insurance. We will work, before the work session document comes before you guys, we will work to add in the language that's been suggested by the DIR and the DOI. The next section is essentially section 13. I don't know I think in the amendment it doesn't have a section number, but it's the last one. Which puts in some changes related to the administration of cost of living adjustments for claimants who were injured prior to 2019. For a very quick history, the legislature in 2019 approved Assembly Bills 370 and Senate Bill 377, which put in place cost of living increases of 2.3% for workers injured prior to 2019. This section of the law applies to claimants with a permanent disability rating or to families of a claimant who died in the line of work, so a death benefit claim. In Nevada, we have lifetime reopening, so there are still thousands of claims on the books dating as far back as into the 1950s that must be administered. The vast majority of those claims are administered by Employers Insurance Company, since we used to be the state industrial insurance system before Nevada privatized workers' compensation in the late 90s. So when the legislature passed AB 370 and SB 377, Employers is responsible for providing most of those COLAs. The way the process is supposed to work is that we pay out the COLAs to the claimant, then we submit documentation of those payments to the DIR. DIR verifies, Division of Industrial Relations. DIR verifies the accuracy and then do an assessment of all the insurers to cover reimbursing us for the outlay of those payments. Assessments of all insurers is how all of the operations and obligations of DIR are funded. However, since the enactment of the bills in 2019, there have been some understandings of how the process should be carried out, resulting in employers paying out the COLAs but not receiving reimbursement. This is an ongoing process, and I believe headway is being made in addressing the monies currently owed, but our goal with the changes in AB 441 is to remove the ambiguity of how this process is administered and provide more direction and timelines to DIR of exactly how the process should proceed and the requirements for everyone in the insurance industry to pay their portion of the cost of the COLAs. Happy to answer any questions.
Did you want to present as well, or stand for questions?
I will present as well. Thank you, Madam Chair. And I am Dalton Hooks. I'm here on behalf of the Nevada Self-Insurers Association. My organization that I represents employers, self-insured employers, and associations of those employers in these matters. And so that's the standpoint from which we come to the table. The portion that I am presenting on for you this afternoon is also in the additional language that has been added to the bill, but it doesn't have a section. It's one of the last ones. But what it does, if I may very briefly, is it seeks to provide parity between those groups that are represented by the Nevada Self-Insurers Association. This provision under NRS 616B371, what our language does is proposes to repeal it, and what it did in 93 and subsequently was revised in 95 after we went three-way and we're no longer a captive state, sought to preclude these associations from either being officers or having a financial stake in a third-party administrator and vice versa, and also precluded them from entering into such contracts. And so the intent here is to provide parity between the employers, insurers, and third-party administrators who can already do this and allow associations to do it as well. And I can certainly answer any questions. Thank you.
Thank you, and thank you everyone for your presentation. Committee members, do you have any questions? Mr. Speaker.
Thank you, Chair. And thank you guys for the presentation. I've got to be honest, I always read through these bills and I'm not quite sure what's happening when I'm reading them because this is not an area I practice in, but I appreciate having you here to explain what's happening. And I appreciate the way that you guys collaborate on these bills. It seems like every session we have one, and I think that's the way the process is supposed to work. So thank you for that. I have two questions. I think one is for Mr. Mills and one would be for Ms. Grimmer. So Mr. Mills, you talked about section 3 and 7 in the amendment. And so I think maybe section 3 and section 7 are addressing different things, but what I heard you say with section 3 was we wanted some sort of transparency, I think, in terms of who is being selected. But then in section 7, we were talking about randomness or random assignment versus rotation. And so I just was hoping you could maybe explain to me in a little bit more detail what section 3 and then what section 7 are trying to accomplish. And are those two things related, or are they completely different issues?
Madam Chair, through you to Jason Mills on behalf of Nevada Justice.
Can go direct.
Thank you very much. Jason Mills on behalf of NJA to Speaker Yeager. Yes, sir. So look, subsection 3 has a reporting requirement for the administrator, the Division of Industrial Relations, to essentially list out the physicians as they get the assignments for their PPD selection, so that they would list out Dr. X received X number of PPD examinations by a random assignment and by mutual agreement. Those are the two ways you can have a PPD done. Subsection 7 does actually 2 things. It actually might do 3 if we get really deep in the woods, but what it does is it, again, removes this notion of the assignments selected in rotation, because that's where we have not been able to get a definitive answer from the division in over a decade exactly how that in rotation selection truly works. And we think by removing the language of in rotation and to randomly would basically base all the names that are in the hopper be able to go in that, be able to be selected for those provisions. Also, the removal of the specialization that I talked about, and then the doctor could then also say that he or she is not willing to accept a rating because it's outside their scope. But if you look at the tail end of subsection 7, there's also a reporting requirement that's similar to that in subsection 3, but slightly different, and I believe that's what you're referring to, that they have to annually indicate the number of times that the doctor was selected and how many he or she actually did. So then we can compare essentially what is he or she rejecting, right? That's where the subtle difference, I think, is between that section of subsection 7 and subsection 3. I hope that answers your question, sir. If not, I'm available for you.
It did. Thank you. Could I ask another question, Madam Chair? Thank you. And I think this one is for Ms. Grimmer. So you had talked about, and I don't remember the 2 numbers, but repealing the 2 cost of living adjustment bills from 2019. And I was trying to look at the amendment, and I thought you were perhaps referring to the deletion of 616B.371, but then Mr. Hooks talked about that section. So I guess my question is, 1, can you confirm that you're looking to repeal those bills? And then is there replacement language that's going in somewhere in the amendment? Because I heard you talk about answering some questions, resolving some ambiguity. Is that in the amendment somewhere?
Thank you for the question, Mr. Speaker. Misty Grimmer for the record. So it is not our intention to repeal what was put into place by those 2 statutes. So 616C 266 is still in place, and the COLAs and everything that was put into place by those 2 bills would absolutely still move forward. What we're looking at when you see in the added green language in that lower section, in that part of the statute, is to put in more structure around the process for how it gets handled at the DIR. So and put in some time frames, because part of the challenge has been that the information has been submitted and then getting responses back has not been very timely, and so the system has really dragged on for quite a while, and employers is in the position of basically having fronted those monies and still waiting for reimbursement. So yeah, we are absolutely not doing anything to change the rights of those claimants and their families to get the COLAs.
And then if I could just one clarifying, thank you. I'm trying to work through this amendment, which for some reason is very small print on my computer. So Mr. Hooks talked about repealing 616B.371, but I guess is the statute that you're looking to change is underneath that? Is it the 616C.266? Is that where the changes are?
Misty
Or
Grimmer.
maybe C.268. I'm just sorry. Tried to make sure I'm looking at the right section.
Yeah.
Mr. Speaker, Jason Mills on behalf of Nevada Justice. I think I might be able to clarify if I may. Please. So if you look on page 26 of the document, and it ends at section 11, because that's where LCB ended. What happens is this next section would be what Mr. Hooks was referring to as the repealing of 616B.371, and if you flip the page to page 27, that's actually striking out 616B.371, and then then there's no delineation to the next section. It just jumps right into 616C.266, which is what Ms. Grimmer is referring to, where they're basically trying to recover their COLA funds that they were essentially promised several years ago, but are having a really hard time getting it. I hope that clarifies.
It does. Thank you so much for walking me through that. I appreciate it. Thank you, Madam Chair.
Assemblywoman Duran.
Thank you, and thank you for your presentation. This is truly an upgrade for the workman's comp. I appreciate that. My question is on when you have a second opinion for, is it just going to be for the permanent or partial disability? You're not gonna be able to other than to get another second opinion just on any denied claim?
Jason Mills on behalf of the Nevada Justice Association. Thank you, Assemblywoman Duran, for that question. The existing law is a statute called NRS 616.145. It already exists and has for several sessions. It allows for an independent medical examination by a claimant in various settings, arguing about the scope of the claim, arguing about the treatment they're entitled to, arguing about whether they should have more care, whether or not their claim's stabled. There is disagreement amongst the parties on whether or not that can be used in a denied claim or not, and this bill doesn't address that particular issue. But what this bill does do is that there was also a section in the IME, the independent medical exam, a statute that as exists had a subsection 5, that is being able to be utilized only for permanent partial disability examinations. The rest of the statute was dealing with true independent medical examinations. So what we had done is in the prior iteration of the bill or of the law is that there is a section that allowed for this IME bill or rule to also be used for PPDs, but because of another statute that exists, there was some confusion on whether or not we could or couldn't use this section in certain circumstances, particularly on a second examination of a PPD. This bill clarifies that we most certainly can, but it has a caveat attached to it, and that is if we use it for that second time around, where I already could use it for the first one, but if we use it for that second time around after a determination by the insurers or the employers have already been made, and we don't get a higher award or a PPD or an impairment number, then the insurers and employers can then recapture the cost only in that second scenario after determination was rendered and that was already on the table, and they could only recover those monies from existing awards that are sitting on the table at that time. I hope that clarifies, and if not, I can continue to answer.
And is it the same process? You have the 30 days to appeal the first deny or your rating?
Jason Mills on behalf of NJA, Assemblywoman Duran. Actually, when insurers issue determinations, we have 70 days to appeal those. Only when the when the administrator of the division is there, typically a 30-day time frame that's allotted. And another part of the bill was attempting to fix that strange 10-day window to make it 30 days. But when insurers render determinations, we have 70 days when we are, quote, aggrieved under existing statute.
Committee members, any additional questions? I don't see any. I have one. So page 16 of the amendment, where you are changing in rotation to randomly. I'm not sure if multiple people can answer this or just you, Mr. Mills. You stated that for a long time, if ever, you couldn't get an answer on how the rotation worked. Did I understand that correctly? Okay. How are we going to know if the randomly is going to work?
Yes, Jason Mills on behalf of the Nevada Justice Association. Thank you, Madam Chair. I think it's one of the ways we're going to do that is with the reporting requirement, right? So now we can see which doctors are getting these assignments through random assignment versus mutually agreed upon. Because the rule allows, say, Dalton and I or Misty and I or through our clients to agree, we both agree to Dr. X. That's a mutual agreement. Statute already says that. When we can't agree, the statute then automatically goes into the rotation assignment, and we have never got a sufficient response from the Division of Industrial Relations on how that process truly works. So if we randomize it, then we should also be able to see, well, aren't on the ones where the parties aren't mutually agreeing, shouldn't those numbers be very similar? And then with subsection 7 that Speaker Yeager brought up, if we then see the numbers that the doctors are rejecting, you can tend to start to figure out it's more open and everyone can see that there's not any funny business going on because you can just really look at the numbers that are being produced, if that makes sense.
It does, so it makes it more transparent
Transparency.
with the reporting. Perfect.
Yes, ma'am.
Thank you, I appreciate that answer. Any additional questions? I don't see any, so we will move to support testimony of Assembly Bill 441. Is there anyone here in Carson City wishing to testify in support of Assembly Bill 441? Please state and spell your name for the record, and you have 2 minutes each.
Good afternoon, Madam Chair, members of the committee and staff. Rick McCann, Nevada Association of Public Safety Officers and a member of the Nevada Law Enforcement Coalition. We're here to support AB 441. Frankly, I don't argue with Mr. Mills on this stuff. He had me at good afternoon, Madam Chair. And I sure as hell not going to argue with apparently the new law firm of Mills, Hooks, and Grimmer. So my attitude is let's go ahead and work session this puppy now and get out of here. Bye.
Good afternoon, committee. Todd Inglesby for the record, President of Professional Firefighters Nevada. We wholeheartedly support this bill. Thanks for the cumulative work by everybody. I can echo what Jason said. I think it might be the first time that I know for sure that I agreed with Mr. Hooks on anything, so it's actually nice. This is about getting our men and women back to work, getting them back to work so they can serve your constituents, and I think that's important, and I think this bill is necessary. Thank you.
Good afternoon, Madam Chair, committee members. Jason Lesher, Lesher, with the Washoe County Sheriff Deputies Association and also the Public Safety Alliance of Nevada. These are some common sense changes to NRS 616, and so we speak in favor. Thank you.
Good afternoon, Chair, members of the committee. My name is Troyce Crumey. I'm the current Vice Chairman of Las Vegas Police Managers Association. We just ditto the comments and are in favor. Thank you.
Thank you. Is there anyone else here in Carson City wishing to testify in support? I don't see anyone. Is there anyone in Las Vegas wishing to testify in support to Assembly Bill 441? I don't see anyone. Broadcast, is there anyone on the line wishing to testify in support?
If you'd like to testify in support to Assembly Bill 441, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 902, please press star 6 to unmute yourself.
This is Mark Segman with the American Property Casualty Insurance Association in support of the bill, particularly Section 10 that allows insurers to adjust claims outside of the state of Nevada. Thank you.
Chair, we have no more callers in support at this time.
Thank you. We will move to testimony in opposition to Assembly Bill 441. Is there anyone here in Carson City wishing to testify in opposition? Please state and spell your name for the record. You have 2 minutes each, and you may begin when you're ready.
Good afternoon, committee. My name is Chantel Schaefer. It's spelled S-H-A-N-T-E-L, and my last name is S-C-H-A-E-F-E-R. I am a licensed and trained professional in the workers' compensation industry here in Nevada. I have undergone extensive training as well as licensure to obtain the specialized handling claims. Passage of AB 441 will directly impact me and my family, as well as many of my coworkers in this industry. Allowing management of Nevada workers' compensation claims out of the state is going to result in numerous jobs being lost and businesses leaving our great state of Nevada. The workers' compensation industry is a predominantly female one and allows females to excel and grow in a specialized and rewarding career, unlike other business sectors. And extensive training and experience is required to handle this important job. If you vote to pass this bill, I, along with many of my industry partners and coworkers, will be unemployed and forced to seek other employment. Thank you for your consideration.
Madam Chair, members of the committee, excuse me. My name is Chaz Nort, N-O-R-T. I'm president of Nevada Alternative Solutions. Excuse my voice, I'm a little hoarse. That said, we've been in business since 1991. I concur and reiterate the comments of the young lady there that just testified. We employ a number of people, and we're opposed to Section 10 language simply for the fact that we've had a brick and mortar statute for decades. And so has a number of the other Western states, namely Oregon, Washington, Idaho, Montana, New Mexico, with similar requirements of having an in-state office to do administration. There's a reason for that. Accountability and enforcement. The DIR will, in my opinion, will be burdened even more than they are now to look at out-of-state adjusters, where the young lady that just testified said, my experience goes back years and years and years. Now, when I opened my office in '91, it required a TPA license, and the adjusters or claims examiners could work under my license. That was the way for many, many years. And then there came a time where I had to get a work comp license, WCR, not only an administrator's license, and then it came a point a few sessions ago where it was required that claims examiners become licensed adjusters in the state of Nevada to adjust claims. They'd already had 4, 5, 10 years of experience. And then they had to take a test and pass it, of course, as would be required by this particular language in Section 10. But can you ensure that the person in Minnesota, New York has 5 years experience or any experience? The language in the Section 10 doesn't even address that. I'm really concerned about claims arising under 616A and 616D inclusive, that a salaried employee of an insurer located in the state can adjust claims without a license? I'd like clarification at least on that. So I employ, as I said, a number of individuals who are exclusively dedicated to insurance carrier-based work. If this door is open to allow insurance carriers to adjust claims outside the state, I'm losing at least 5 to 8 employees. I can tell you that right now. They've been with me for 15 and 20 years.
And if you can please wrap up your testimony, it's been 2 minutes.
And that's our concerns. You're going to lose jobs in Nevada. It's bad for Nevada. It's bad for Nevadans. And is it good for the all? I don't think so. Thank you.
Thank you for your testimony.
Good afternoon, committee. My name is Julie Alvarez, Juliealvarez. I'm a licensed workers' compensation claims adjuster here in Nevada, and I have undergone extensive training as well as licensure to obtain this specialized position handling claims. I'm the breadwinner in my family. I provide financial support to my elderly family members. All my concerns have been outlined in prior testimony. Therefore, for the reasons already stated, I do not support this bill. Thank you.
Good afternoon to the leadership and the committee. My name is Sharon Oglesby. That's SharonOglesby. I am also a licensed workers' comp claims adjuster here in Nevada, and I also have undergone extensive training as well as licensure to obtain this specialized position handling claims. All of my concerns have been outlined in prior testimony. Therefore, the reasons already stated, I do not support this bill, AB 441, subsection 10. I believe that we need to preserve the jobs in Nevada. Thank you.
Hello, my name is Stacy Jones, STACI-JONES. I am also a licensed workers' compensation adjuster. In respect to the committee's time, I echo the statements of those who've gone before me, and I appreciate your time in opposition to AB 441. Thank you.
Hi, my name is Tani Consiglio. That's TANICONSIGLIO. I'm also in the workers' comp industry, where I have been working for many years. I also echo against this bill, as I am a breadwinner as well in my family, and I've been doing the workers' comp, and I think it's very important that we keep the jobs in the state of Nevada to adjusters that are knowledgeable in that area. Therefore, I echo against this bill. Thank you.
Good afternoon. My name is Lydia Perez, Lidia Perez. I'm also in the industry for over 20 years. This has been my career for all those years, and I've been handling the claims. I'm opposed to the bill as stated previously by my colleagues, so I'm opposing to that. Thank you.
Hi, my name is Kim Campa, excuse me, K-I-M, C as in cat, A, M as in Mary, P as in Paul, A. And in respect of your time, I do echo the statements before me, and I'm here in opposition of AB 441. Thank you.
Thank you for your testimony. Is there anyone else here in Carson City wishing to testify in opposition to Assembly Bill 441? I don't see anyone. I do see individuals sitting. If you are sitting in opposition to Assembly Bill 441, please state and spell your name for the record. You have 2 minutes, and you may begin when you're ready.
Thank you very much. My name is Ann Davison Glendenning, Glendinning. I've been an insurance professional here in Nevada for 32 years. I object to Section 10. We've been talking about the residency since 1990 when Fremont Insurance Company came in to make its acquisitions, which obviously ended up as employers. I completely understand the financial benefits for carriers to take this out of state. It's very real. I understand that. However, it is not the time here in Nevada. We need to support our state agencies because currently we are in a crisis state, and we've addressed the Department of Administration based with the new hire. However, the Department of Insurance needs to re-look at their licensing and the education aspect of their licensure, because with this, they would have to have a license that is reciprocal over the states. Currently, the state has a staff license, which is not reciprocated. The state required that most professionals that had national adjusting licenses relinquish those to acquire this particular license. That would all have to be reworked, and we'd have to have a relevant test, as well as be able to adjudicate the education. They asked for Texas education when this all started, saying Texas was the same as Nevada. It's not. I assure you, it is not. So we need to look at that. Next would be the Department of Industrial Insurance. They don't have the technology or the talent to be able to do this. They are struggling with what they have now. As Mr. Mills kindly said, everything's paper, everything's archaic. They don't have the tools, and now they don't have the talent either to pursue this. You need to hire insurance professionals to run the Department of Industrial Insurance. Currently, that's not in place. Then last, I'd ask that it is not the problem at the adjuster's desk. That's not where this starts and stops. The problems that we are having in Nevada are a result of our state agencies and the system having the challenges that we have not been able to overcome. Those need to be addressed.
Ma'am, if you can please wrap up your testimony.
Absolutely, thank you.
Thank
I
you.
ask that you not include Section 10 in this bill. I think the rest of the bill is pretty good, but Section 10 and taking the residency out, it's not the time. Put it aside. Let's address it in another 2 years. Thank you for your time.
Thank you for your testimony. You may begin when you're ready.
Thank you. My name is Nicole Marley. I'm currently a claims compliance officer for 27 years. I've been doing this work. I'm concerned about the implications of this bill in allowing our out-of-state adjusters to perform Nevada claims administration. 13 years ago, I found myself a single parent. This career gave me stability where I could provide for my children. In our industry, there's a large percentage of claims adjusters that are single parents, and this bill would significantly reduce the state adjusters in Nevada, leaving Nevadans out of work. We have over 300 licensed adjusters in Nevada and will be significantly reduced because of this Section 10 of this bill. I stand in opposition of this bill, and I hope that you make the right decision to allow Nevadans to continue to work. Our unemployment rate is extremely high right now, and like my colleague said, I echo her in saying that just now is not the right time to do this, maybe later, but not right now. Thank you for your time.
Good afternoon. My name is Diane. I'm a workers' compensation supervisor in the state of Nevada. I also hold a Nevada resident adjuster's license. If you pass the bill, it will not only impact me financially, as I'm the sole provider for my household, it will impact most of my family that I work with, and a lot of people in Nevada will lose jobs that we cannot get reemployed. Thank you.
Good afternoon. Excuse me. My name is Tameka Lawson, Tameka Lawson, Lawson. I'm a supervisor in workers' comp as well as a native of Las Vegas, Nevada. I'm here asking you to reconsider the passing of AB 441 as it will impact me, my peers, as well as my coworkers. As a primary breadwinner of my family and a mother of 6, one of whom has special needs, the bill could potentially place me out of work. Sorry, and unable to care for my family's financial needs. Given my family commitments, which includes taking care of my grandmother and my parents, I can't move out of state to work at another location for employment. Thank you for your time, and please reconsider passing AB 411.
Good afternoon. I'm Shannon Coggins. It's SHANNONCOGGINS. I'm a Nevada native of 28 years. I'm a supervisor for a third-party administrator handling workers' compensation claims. I hold a Nevada resident adjuster license, and I've been in this industry for 7 years. I'm here to ask for you to consider the effects of AB 441 subsection 10. If this law passes, it will directly affect my job and the jobs of my peers. Passing this law will allow for outsourcing to another state, which will eliminate my job and the job of my coworkers. I am the sole provider of my household, and this bill passing would directly affect my ability to provide the basic necessities for me and my household. Thank you.
Good afternoon. My name is Brittany Turner, Brittney, last name Turner, Turner. I'm a native of Las Vegas, Nevada. I was born and raised here. After going through many of jobs, I chose this career because of how it helps people and because of the stability that it gave me to provide for my family. So I'm definitely in disagreement of Section 10 to be specific. I do feel like this is a job where, I spent a lot of time and energy studying for the test, and I knew it was something specific that I can hold on to, to possibly retire from, because I am new. I just actually got my license within the last year. So it's very important to me. It's not easy. They say it's a lot of jobs out there, but it's really not easy. So I don't want to go back through the unemployment process. I appreciate my coworkers, and moving it out of state, I just don't think that the way we handle the claims being here, I do think it'll affect the claimants and the time and effort that we put into our claims and getting these claimants back to work and getting them paid so they can take care of their family as well. So I am definitely opposed to Section 10. Thank you for your time. Have a good day.
Marianne Carlisle, MARYANNCARLILE. I am a licensed claims adjuster in the state of Nevada in opposition to Section 10. Prior to being an adjuster, I was laid off due to the pandemic. With a newborn at home and a partner who was also laid off, I was forced to find new work. I got into workers' compensation because I've always wanted to help people. And when I was finally licensed, I knew that I could make a living doing something that made a difference for people who were going through a really difficult time in their life. With that being said, I started working full-time while my partner stayed at home to care for our child. This specific job has also given me the opportunity to meet in person with some injured workers who have more severe injuries to better understand their injury and also reassure/support them during their recovery, which has been really eye-opening for me. I work with a dedicated client, which means that this new legislation could result in the elimination of my position, ultimately leaving me without an income. With that being said, I'm just one of many people that would be affected by this. There are always two sides to a story, so this is the side that I would hope that you consider before putting anything into law. Thank you.
My name is Alida Fluellen, A-L-I-D-A, Fluellen, F as in Frank, L-U-E-L-L-E-N. I'm a Nevada resident, a licensed adjuster. I've been in the industry over 40 years, and I am a sole provider for my family and my household. If AB 441 is passed, this would affect my financial ability to support my family, as well as the financial effect for my coworkers and all Nevada licensed adjusters. I echo the opposition.
Good afternoon. My name is Lashika Durden, and that's L-A-S-H-E-K-A, last name D-U-R-D-E-N. I am a licensed Nevada adjuster, and I'm here today in hopes for the reconsideration of the AB 441 Section 10 bill. This passing of the bill will not only affect all Nevada adjusters as a whole, but it will affect our families and how we take care of them. A lot of us are still recovering financially from the 2020 pandemic, and now 3 years later, we are facing the threat of the loss of our job security. So today, I stand with and represent all Nevada adjusters when I say, I hope that you sit down and discuss the passing of the bill and take into consideration that we're not just adjusters, we are wives, we are husbands, we are parents, we are grandparents, and we are caretakers. Not only are we trying to help and better the lives of our Nevada injured workers, but we're also trying to help and better ourselves and our families. Thank you.
Good afternoon. My name is Leida Herrera, L-E-I-D-A-H-E-R-R-E-R-A. The passing of this bill, Section 10, could result ultimately in losing my job. In Nevada, there are many TPA offices that are specifically handling Nevada claims. This would make it difficult for me to find work in this field elsewhere, which would negatively affect me and my family. I am the primary wage earner in my family. It may further require to have to move my entire family out of state just to find work in my field. This will be a financial hardship and devastation to many people. I do not support this bill. Thank you.
Good afternoon. My name is Melissa Cristobal, M-E-L-I-S-S-A, C as in cat, R-I, S as in Sam, T as in Tom, O, B as in boy, A-L. I am currently a workers' compensation claims examiner working for a TPA. I've been in the business in Nevada for over 2 decades, and I'd like to emphasize that the passing of AB 441 Section 10 does also affect the TPAs, the third-party administrators, because we do handle claims for the carriers that are not in Nevada. For me personally, it will impact my financial well-being because I am the sole provider for my household, and also having this be moved out of state will also include harming the well-being of my mother because she is here. So I urge and greatly hope that this Section 10 does not pass. Thank you for your time.
Good afternoon to the leadership and this committee. My name is Deanie Helget, D-E-A-N-N-I-E, Helget, H-E-L-G-E-T. I am a licensed workers' compensation claims adjuster here in Nevada. I have undergone extensive training as well as licensure to obtain this specialized position handling claims. I too am the breadwinner of my household. All of my concerns have been outlined, in prior testimony. Therefore, for the reasons stated, I do not support subsection 10 of this bill. Thank you.
Good afternoon. My name is David Martin. That's DAVID-MARTIN. I'm here representing myself as a Nevada State resident licensed workers' comp claim adjuster. I'm in opposition and I implore you, esteemed assemblymen, to consider my plea to deny the passing of AB 441, Section 10. I am the main provider for my young family, which consists of my wife and 3 girls who are 11, 9, and 3. My family and I had relocated to the state of Nevada a little over a year ago to expose and provide our girls with better opportunities than what my wife and I were afforded when we were younger. If this bill passes, it will most certainly have a detrimental effect on my ability to support my family financially, essentially denying the very reasons why we brought our kids here in the first place, as Section 10 amends NRS 684A and opens up the landscape regarding carriers handling claims from outside of the state. The passing of this bill will most certainly affect and jeopardize my current employment as well as those of my fellow coworkers. Thank you.
Good afternoon. My name is Marcia Spear, M-A-R-S-H-A, S-P-E-A-R. To the leadership and this committee, I would like to state my opposition to AB 441, Section 10. I am a licensed workers' compensation claims adjuster here in Nevada. I've been in the industry over 30 years, and I have extensive knowledge, and I've gone through much training as well as licensure to obtain this specialized position handling claims. I provide financial support in order to maintain my household. All of my concerns have been outlined in prior testimony. Therefore, for the reasons stated, I do not support this bill. Thank you.
Hello, my name is Adriana Patterson. It's A-U-D-R-I-A-N-A, Patterson, P-A-T-T-E-R-S-O-N. I am a Nevada resident licensed adjuster and a mother of 3. I am testifying today and ask that you please do not pass Bill AB 441, subsection 10. If this section of the bill is passed, it will financially affect my ability to provide for my 3 children, and I will be without a job. Thank you.
Hello, I am Alma Larios, A-L-M-A-L-A-R-I-O-S. I am a Nevada resident workers' compensation supervisor. I hold a Nevada resident adjuster's license. If you pass AB 441, subsection 10, regarding carriers handling claims out of state, I will not be able to financially support my elderly mother, my sister who has Down syndrome, as well as paying the tuition for my child for college. Subsection 10 of this bill, if passed, will also impact the livelihood of all my fellow coworkers, as well as all Nevada licensed resident adjusters. I ask that you carefully take into consideration the testimonies that you're hearing today and consider the impact that you will place on Nevada resident adjusters and their loved ones.
My name is Jennifer Monolakos, Jennifer-Manolakos. I've been a claims adjuster in Nevada since October 31st of 2002. You asked us to get licensed, and at that time, I already had 10 years of experience under my belt. The passing of subsection 10 will take away my ability to not only financially support my family, but medically support my family. People know me as just a claims examiner. They don't know the human side of me. That is right now. I am supporting my husband going through cancer treatments. I have a son who gets monthly MS treatments. Moving claims out of state potentially means that I lose my job.
I would no longer be financially or medically able to support them. I am asking you to please carefully consider this and not approve subsection 10. Thank you.
Good afternoon. My name is Jacqueline Bell. That's JACKELINE BELL, and I'm a licensed claims supervisor. I'm here today hoping for a reconsideration of AB 441 subsection 10. I'm here today as a concerned citizen because this bill will have the potential to directly affect not only my career, but the careers of my peers. This bill will eliminate our job security, which will have a trickle effect across the state of Nevada and leave many of us without a job. Please reconsider AB 441. Thank you.
Good afternoon to the leadership and this committee. My name is Christian Saavedra, Christian Saavedra. I'm a licensed workers' compensation adjuster here in Nevada, and I have undergone extensive training as well as licensure to obtain this specialized position handling claims. I am proud to be in the profession that I am in helping my community and my fellow Nevadans. Please reconsider Bill AB 441, subsection 10. I am not in support of it. Thank you.
Good afternoon, everyone. My name is Tony Rose de Guzman, TonyRosedeguzman. I am a claims team lead. I have been in claims for over 12 years. This bill, if it passes, may impair my career, along with a lot of people within the industry and our community here in Nevada. It affects hundreds of people's current livelihoods. This bill removes the assurance that we can continue working our current job for the foreseeable future. It takes out the certainty that our employment status can stay consistent. I am here today as an interested individual asking for the reconsideration of AB 441 subsection 10. Thank you.
Good afternoon to the leadership and this committee. My name is Christine Guerrero, spelled CHRISTINEGUERRERO. I am a licensed workers' compensation claims adjuster here in Nevada, and I have undergone extensive training as well as licensure to obtain the specialized position handling claims. All of my concerns have been outlined in prior testimony. Therefore, the reasons have already been stated. I do not support this bill.
Good afternoon. My name is Daniel Stallings, DANIEL STALLINGS. I first moved to the state 2 years ago in search for better opportunities, cost of living, somewhere where I could actually put down roots. So that's why I'm here. I can only speak to my personal experience. I don't have any family here. I'm just here by myself. Though I do take care of my elderly family in Carolina. Father's going through cancer treatments. I pay for those. What I want you to understand is if you're truly wanting to take care of an injured worker and get them back to work and get them what they need, you need someone who lives in the state, who wants to be here to push that forward. Thank you very much.
Hi, good afternoon. My name is Christy Feldman, spelled Kristi, Feldman, F as in Frank, ELDMAN. And with respect to the committee's time, I do echo the statements before me and am here in opposition of AB 441. I'm an RN and board certified case manager. I work with a TPA for workers' comp with the adjusters hand in hand to make sure that they do have the best medical care. So therefore, passing subsection 10 would definitely affect our ability to work together and best serve the injured workers in Nevada. Thank you.
Hello, my name is Laketa Durden, Laketa Durden. I am a Nevada adjuster. I am in reconsideration of this Assembly Bill subsection 10. I feel it would be unfair for Nevada adjusters to have out-of-state adjusters to take over Nevada claims and/or position. It is beneficial for Nevada adjusters who have the knowledge and experience with Nevada statutes to continue claims within Nevada due to all the hard work and determination we all have put in to retrieving our licenses. This decision doesn't only affect myself and my colleagues, but also our family as well. I openly reject the passing of this bill.
Good afternoon to the leadership and to this committee. My name is Susan Riccio, SUSAN-RICCIO. I am a licensed compensation claims adjuster here in Nevada, and I have undergone extensive training as well as licensure to obtain a specialized position handling this claims. All my concerns have been outlined prior to the testimony. Therefore, for these reasons already stated, I do not support this bill. Thank you.
Good afternoon to the leadership and this committee. My name is Candace Egan, CANDICEEGAN. I am also a licensed workers' compensation claim adjuster here in Nevada. I am the steady provider for my household. All my concerns have been outlined in prior testimony. Therefore, the reasons already stated, I do not support this bill, AB 441, Section 10. Thank you.
Good afternoon, leadership and committee. My name is Arturo Sierra, ARTURO SIERRA. I am a licensed workers' comp claims examiner. I have been in this field for over 20 years, and I love to do what I'm doing, help people get better. The passage of the Assembly Bill 441, subsection 10, will directly affect me and my family. I encourage you to not pass this bill. Thank you.
Good afternoon to the leaders and the committee. My name is Taisha Jones, spelled THIESHA. I am also a claims license adjuster for Nevada, also a single parent of 3, and if this bill is passed, it will not allow me to take care of my children, and as for also my personal health, having multiple sclerosis. It will put a burden on my family. And as I already stated in those other reasons, I also oppose to this bill. Thank you.
Good afternoon to the leadership in this committee. My name is Wendy Mackey, that's WENDY, M as in Mary, ACKEY. I'm just starting my career in workers' compensation, awaiting the assignment of my license from the Division of Insurance. I believe this bill will eliminate jobs in the community and possibly my job or my coworkers' jobs. All of my concerns have been outlined in prior testimony. Therefore, the reasons already stated, I do not support this bill. Thank you.
Good afternoon, leadership and committee. My name is Tina Harrison, TINAHARRINSSON. I am a claims professional in the state of Nevada. For reasons already stated, I oppose this bill.
Is there anyone else in Las Vegas wishing to testify in opposition to Assembly Bill 441? I don't see anyone. Broadcast, is there anyone on the line?
Callers, if you'd like to testify in opposition to Assembly Bill 441, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 347, you are unmuted and may begin.
Hi, good afternoon, the leadership in this committee. My name is Maria Solorzano, spelled MARIA SOLORZANO. I am a licensed workers' comp adjuster, and as for all the reasons already stated, I oppose the bill, AB 441, subsection 10.
Good afternoon to the leadership and the committee. My name is Michelle Green,
spelled MICHELLEGREEN. And I've been in the work comp industry for over 25 years and not ready to retire anytime soon. In respect of the committee's time, I concur with the statements made before me, specifically on subsection 10, which would threaten my livelihood and those of my coworkers. I am calling to voice my opposition to Assembly Bill 441, subsection 10. Thank you for your time.
Thank you for your testimony. Broadcast, is there anyone else on the line?
Chair, there are no more callers in opposition at this time.
Thank you. We will move to testimony in neutral here in Carson City. Please state and spell your name for the record. Thank you.
Good morning, Madam Chair, members of the committee. I'm Victoria Carrion. That's spelled Victoria. Last name is spelled Carreon. I'm the administrator of the Division of Industrial Relations, and we are the regulatory agency regarding workers' compensation for Nevada. So the bill does have an impact on our agency, so I just wanted to cover some of those things, and we did submit a fiscal note for consideration. Sections 3 and 7 require quarterly and annual reports on the number of rating exams that have been completed. We currently do not collect that data. We have the data on the number of ratings that have been assigned, so we would need to be collecting that data from insurers and would need to set up a system to do that. In addition, Section 6 allows for a second disability rating, and we currently do an average of 5,349 ratings per year. We believe that this addition of allowing for a second rating would increase the demand by about 33%, and so that would have an impact on our workload as well. And then finally, Section 9 provides that our agency would have no further jurisdiction over investigating benefit penalty complaints after 90 days. It's important to note that benefit penalty complaints investigations are very complex by the time a claim gets to that point. There's been many years of history typically, and it's a very complex claim to investigate. We currently have 2 compliance audit investigator, 3 positions. Each of them can do 4 of these per month. There's also a supervisor of those positions, a chief compliance audit investigator. She does about 2 of these per month. We have had about 230 of these investigation requests per year over the last couple of years. So with the current staff level that we have, we can do 120 of them within a year. So that leaves 110 of them that would remain to be done. And so we would need additional staff resources in order to do them within the 90 days. Thank you.
Thank you for your testimony. Is there anyone else here in Carson City wishing to testify in neutral? I don't see anyone. Is there anyone in Las Vegas wishing to testify in neutral to Assembly Bill 441? I don't see anyone walking up. Broadcast, is there anyone on the line wishing to testify in neutral?
Chair, there are no callers in neutral at this time.
Thank you. Mr. Mills, would you like to give closing remarks? Mrs. Grimmer and Mr. Hooks.
Madam Chair, Jason Mills for the Nevada Justice Association, along with Misty Grimmer from Employers, and Dalton Hooks from Nevada Self-Insured. We'd like to thank you for your time today and for this bill. Like I said, we worked hard and diligently to get major stakeholders involved on this particular bill, and we think that we have done so. I did hear from, I noticed there at the end with regard to the administrator, some points with regard to the denials on the claims. The problem is the statute already deems them denied by the 90th day. So the problem, what we have pointed out, that once a denial is in place as a matter of law, how does the agency then continue to have jurisdiction over something that its law has already said they've denied? So to that end, they would no longer have to investigate them. As you are well aware, as being in court, the triers of fact, judges, by evidence being presented to them by the parties, are very capable of determining whether or not an insurer or a party has done something wrong or improper. So in fact, we see it as not a cost to the division, yet rather a relief from some of that pressure. So with that, we think that this particular bill, as we put forth as amended, should proceed. Thank you. And any questions you have, I'm here to respond to.
Thank you, Chair Marzola and committee members, and thank you for taking the time to listen to this and consider this bill and all of the testimony. With respect to the claims adjustment, I did just want to point out that there's nothing in the bill that mandates that all insurance company claims adjusting is going to leave the state of Nevada. It just gives the flexibility to insurance companies who would like to have it more located wherever they may be, which may not be in the state of Nevada. And also, nothing in the bill changes whatever licensure or certification the state of Nevada requires for adjusters to have in order to adjust claims. So even if they're in New York or wherever they happen to be, they still would have to have the same certifications that are required currently. It's my understanding from talking to others in the industry that there's actually a shortage of claims adjusters in the state of Nevada. So I would hope that all of those fantastic people that testified about how hardworking they are, more than likely, I would hope, would be able to keep their jobs in the trade that they're in. Thank you.
Madam Chair, I don't have any additional comments unless there are questions for me, but thank you for your time. We appreciate it.
Thank you so much. No questions. I will now close the hearing on Assembly Bill 441. I will now open up for public comment. Please address your remarks to issues that fall within the jurisdiction of this committee. Public comment is limited to 2 minutes. Please remember to state and spell your name for the record. Is there anyone here in Carson City wishing to give public comment? I don't see anyone. Broadcast, is there anyone on the line wishing to give public comment?
If you'd like to provide public comment, please press star 9 now to take your place in the queue. Chair, we have nobody on the line wishing to provide public comment at this time.
Thank you so much. This concludes our meeting, our first meeting for today. Our next meeting will be Monday, April 10th, today, later at 6 p.m. This meeting's adjourned.